Judgment in the matter of Veale and others against Scottish Power UK.
Robert Crozier died of mesothelioma in 2018. In this appeal, the Supreme Court is asked to decide whether members of his family can claim damages from his former employer, Scottish Power, under the Damages Scotland Act of 2011. Mr. Crozier was employed by Scottish Power for much of his life. In 2014, he sued his former employer for damages, having developed pleural plaques and contracted asbestosis as a result of being exposed to asbestos in the course of his employment. The claim was settled by agreement. Mr. Crozier was not suffering from mesothelioma at the time of the settlement, but the sum that he received included damages for the risk of his developing mesothelioma in the future. That discharged Scottish Power's liability to Mr. Crozier so that he could not claim further damages from Scottish Power if he went on to develop mesothelioma. Following Mr. Crozier's death from mesothelioma, members of his family brought a claim against Scottish Power seeking damages under the 2011 Act for the distress, grief and loss of society caused to them by Mr. Crozier's death. Scottish Power argues that damages are precluded by Section 4.2 of the 2011 Act, which sets out a general rule preventing relatives from claiming damages where the injured person has already settled their own claim for damages arising out of the same wrongdoing. In response, the pursuers rely on Section 5 of the 2011 Act, which provides an exception to the rule in Section 4.2 where the deceased died from mesothelioma. The exception applies if three conditions are met. Scottish Power accepts that two of the conditions are satisfied, but it argues that the third condition, a condition in Section 5.1a, which requires that the defender's liability to pay damages to the deceased was discharged by the deceased before his death, they argue that that is not met because Mr. Crozier was not suffering from mesothelioma at the time when his claim was settled. Scottish Power's arguments were rejected by both the outer and the inner house of the Court of Session, but the inner house granted Scottish Power permission to appeal to the Supreme Court. The Court unanimously dismisses the appeal. It holds that the condition in Section 5.1a that the liability to pay damages to the deceased is discharged by the deceased before their death is met, and that it contains no requirement that the deceased was suffering from mesothelioma at the time when his claim was discharged. The Court begins by considering Scottish Power's argument that the phrase liability to pay damages in Section 5.1a refers specifically to a liability to pay damages for mesothelioma, and not to a liability to pay damages for personal injury more generally. Scottish Power's case is that no such liability was discharged when Mr. Crozier's claim was settled because he had not yet developed mesothelioma. The Court rejects this argument for three reasons. First, even if Scottish Power is right that Section 5.1a refers specifically to a liability to pay damages for mesothelioma, it would not change the outcome of the appeal because that liability was discharged by the settlement Scottish Power reached with Mr. Crozier. Secondly, the phrase liability to pay damages appears in Sections 3 and 4 of the 2011 Act as well as in Section 5. It has to have the same meaning in all three sections because of the interconnections between them. Section 3 is concerned generally with people who die as a result of personal injuries caused by the act or omission of another person. It is not restricted to those with mesothelioma. It follows that Section 4 is equally wide in scope. So when Section 4.2 lays down the general rule preventing relatives from recovering damages in cases where the deceased has already discharged their own claim, the liability to pay damages to which it refers cannot be restricted to liability to pay damages for mesothelioma. The phrase liability to pay damages must have the same meaning in both Section 4.2 and in Section 5.1a, because Section 5.1a is creating an exception to the general rule in Section 4.2 and uses exactly the same language. Section 5.1a says nothing about mesothelioma. The mesothelioma condition for the exception to apply appears instead in Section 5.1b, which requires that the deceased died from mesothelioma, and it's accepted that that condition is met in this case. Thirdly, Scottish Power's argument is self-defeating. As I've explained, the phrase liability to pay damages must have the same meaning in Section 4.2, which lays down a general rule, and in Section 5.1, which creates the exception. Scottish Power says that the phrase refers to a liability to pay damages for mesothelioma for which the deceased must have been suffering at the time when the liability was discharged. But if that is right, then the general rule in Section 4.2 would not bar the claim by Mr. Crozier's family, since he settled his claim before he developed mesothelioma. The Court goes on to reject Scottish Power's contention that the heading of Section 5, which is discharge of liability to pay damages, exception for mesothelioma, indicates that the whole section is concerned with a discharge of liability to pay damages for mesothelioma. It finds that the heading is consistent with the Court's straightforward reading of the provision as accepting from the general rule in Section 4.2 the relatives of anyone who died of mesothelioma after having discharged the liability to pay damages. The Court also rejects Scottish Power's argument based on the background to the 2011 Act. It reenacts provisions originally found in another statute passed in 2007. Before that Act was passed, mesothelioma sufferers faced a dilemma. They could either pursue their own damages claim before they died, or they could leave their executor and relatives to make a claim after their death, usually for a much higher value. Most sufferers chose not to pursue their own claims because they did not want to disadvantage their families. The Scottish Executive's policy memorandum on the bill, which became the 2007 Act, explains that the legislation was designed to remove this dilemma. The Court recognises that the provisions of the 2011 Act and the predecessor provisions in the 2007 Act go further than is necessary to achieve that policy aim. But it doesn't follow that the meaning of Section 5.1a should be distorted for three reasons. First, although understanding the problem that a piece of legislation was designed to address can help the courts in ascertaining its meaning, it can't displace the meaning of the words actually used in the statute where they are otherwise clear and unambiguous, as they are in the present case. Secondly, Section 5 would have to be substantially rewritten in order to limit its effect to the removal of a dilemma which I've described. The courts can't rewrite legislation in that way. Thirdly, limiting the Section 5 exception to individuals who knew that they were suffering from mesothelioma when their claims were settled and therefore faced the dilemma would have excluded those who didn't yet know they had developed the disease, and would also exclude people like Mr. Crozier who developed the disease after their employer's liability was discharged. It's understandable that legislation should have been drafted in a way which avoided the need to draw distinctions of that kind. Finally, the Court considers Scottish Power's submission that Section 5 should not be interpreted in a way that produces an absurd or anomalous result. Scottish Power says that it's absurd that Mr. Crozier's family should be able to claim for loss suffered as a result of his disease when he couldn't make the claim himself. But Section 5 is designed to enable relatives to bring a claim even after the wrongdoer's liability to the deceased has been discharged. That is the whole point. Scottish Power also claims that it's anomalous that the Section 5 exception should be available only to the families of those who've died from mesothelioma and not to those who've died from other fatal conditions resulting from exposure to asbestos. But that also is a result of a policy underpinning Section 5, which is designed specifically to create an exception for mesothelioma. For all these reasons, the appeal is therefore dismissed. The Court will now adjourn.